I'm getting to know you now.
You said you must Thank you. Thank you, everybody, and good morning. Good morning, everybody. Ms. Batlenda, we are in your hands. Can you just let us know how we're going to proceed?
Thank you, Chair. Good morning. Advocate Bauer is on Skype and ready to participate for re-examination purposes from there, and we're in the middle of the cross-examination of Mr. Hofmeyer, so perhaps we could continue with that.
We continue with...
Mr. Arendse was cross-examining.
He was
Mr.
busy with
Hofmeyer.
cross-examination, yeah.
That's correct.
Okay. Mr. Arendse,
Chair.
you are permitted to continue where you left off yesterday with your cross-examination.
Madam Chair.
Yes, ma'am.
Madam Chair, I've been instructed by Mr. Hofmeyer to make the following representations to the panel for their consideration. It is with regard to the case law that he was referred to last night to provide possible to be cross-examined on. And if I may proceed, I would like to make the following submissions. It is to, first of all...
Yeah, okay. Yeah.
To revisit the purpose of the inquiry. The purpose of the inquiry, as we understand it, is for the purposes of making an inquiry to determine whether somebody was guilty of misconduct or whether they're no longer a fit and proper person to hold the office at the NPA in terms of Section 12(6) of the NPA Act. Now, the subject matter, as we understand it in this inquiry, is the conduct of Mr. Mrwebi and Ms. Jiba. Their conduct, as we understand it, is currently under scrutiny. Now, Mr. Hofmeyer did not arrive at the door to give evidence. He was approached by Ms. Bauer, the evidence leader, to provide evidence in this matter, and he was specifically asked to provide evidence on the framework within which members of the NPA, the function was established. In terms of that, he was also asked to then refer to what the framework entails and as it relates to the roles that Ms. Jiba and Mr. Mrwebi played, in specific reference to when it came to Mr. Mrwebi, what the phrase "in consultation" meant. As far as Ms. Jiba is concerned, the racketeering decision. And in evidence, Mr. Hofmeyer provided evidence that he had personal knowledge of being heading up the AFU in relation to the Medluli matter. He had personal knowledge in terms of the Boysen matter in the sense that Nkusana asked him as an EXCO member to investigate the decision and circumstances surrounding that decision. And he further had personal knowledge in that he had to assist after the arrest of Mr. Gerinel to have him released in order to be able to deal with the Celebi matter. Now, on Thursday, the Mosing affidavit was put to Mr. Hofmeyer for a response, and specifically paragraph 12. In his attempt yesterday to respond to that, and I want to emphasize that paragraph 12 related to the Boysen matter and is pertinent to the frame of reference or the scope of reference of the inquiry as it relates to decision taken by Ms. Jiba. He was interrupted and he had not had an opportunity to fully respond thereto. However, he was put at ease when it was conveyed that those matters will be likely revisited during re-examination. Now, in fairness, and it really goes to fairness at the end of the day, it should be considered, what is this inquiry not about? It is not about the conduct of Mr. Hofmeyer. There is no reference and therefore no relevance to the conduct of Mr. Mrwebi or Ms. Jiba in the case law or memos proposed by the legal counsel of Ms. Jiba yesterday. Mr. Hofmeyer is not an accused and is not the subject of this inquiry either. The evidence that were made available to Mr. Hofmeyer last week, as it relates to the Dropbox and as it relates to his evidence, did not contain any matters, the case law in question that he was referred to yesterday or the memo that he was referred to yesterday. And it is therefore clear from where we are sitting that that evidence was not envisaged by the evidence leader. I cannot propose to comment on that. I'm sure she will. But as it stands, it's our submission that this witness is going to be turned into an accused. Alternatively, that he's going to be made subject to an inquiry which was not properly constituted. I would like to refer the panel to the matter State versus Mulder in 1980, where it was the rest of the citation, is 1981 SA 113 and between brackets T. Now, in that case law, it was determined that where evidence is laid that falls outside the scope of inquiry or the terms of reference of a commission, that would constitute it to be ultra vires. That decision was also followed in the Constitutional Court. I unfortunately do not have the full reference available, but it was in the well-known President versus Sarfu matter. So that decision still stands.
That President versus Safu is not a short judgment. You can't just...
I understand. I'm very willing. I have it in here somewhere between all the papers. I will get it out and make it available. The point being that that decision of Mulder was followed by the Constitutional Court. As far as fairness is concerned, this is really what our objection is about, that Mr. Hofmeyer was not presented with this turn of events in proper time. He has not had an opportunity to consider the papers that gave rise to the decision in those case law, where it pertains to any decisions or actions on his part. It is his submission that in order to properly answer thereto, he needs an opportunity to do so, and in doing so, he would effectively have his conduct evaluated, and that we submit should form the basis of an inquiry in terms of section 12.6.
You do understand that you make a point here that he is not the subject of the inquiry, and this process of cross-examination would expose him to being a suspect. But you accept that nobody is a suspect in this matter?
Madam Chair, we realize that. However, in the matters concerned, Mr. Hofmeyer's conduct might come into question, which would mean that he would then effectively be subjected to an inquiry, whereas the inquiry has not been properly constituted. He was not made aware of such a possibility before coming here, and it is also our submission that, as far as we're concerned, we are not aware that the evidence leader had envisaged this.
Ms. Patlenda, I know Ms. Bauer is on the other side, but may I direct this to you? Would you have anything to say or to add in response to that submission?
Can I ask one final question? Would it be open to your client to refuse to answer questions? In terms of his rights, not to be impacted by questions that would tend to lead to such an inquiry as you assert.
Madam Chair, I have also referenced an article, if I may just be permitted to give you a citation thereof. It was published in Hein Online, and the article I'm referring to is an article entitled Notes on the Nature and Conduct of Commissions of Inquiry, South Africa, and the author of the article is A.J. Middleton, a professor at law of the University of South Africa. In that article, he refers to a subheading as regards the rights of witnesses in commissions of inquiry, and specifically to a witness's right to refuse to testify. And under that heading, he makes the comment that if the Commission calls upon the witness to testify on matters outside the terms of reference, it is acting ultra vires, and the witness is entitled to refuse to testify, and that references the case law that I've provided to the Commission. It is our submission that, that the case law in question and what Mr. Hofmeyer is being asked to testify on indeed falls without the terms of reference. Outside, sorry.
Terms of reference.
But I was asking with specific reference to a particular question where a question is posed and your response is, I refuse to answer the question on the basis set out. Are you saying that because then it would be question by question? Would you suggest that's how it should work?
Madam Chair, in light of wanting to save time, we could proceed on a question-by-question basis, but that will be the response to all questions as it relates to the case law and the memo in question for the reasons that we've advanced. I just want to reiterate again, I did
say... Sorry for the case in question, not the memo in question. We're dealing with a case and not a memo.
We're dealing with the cases and the memo. The memo they referred to yesterday, as far as we understand it, we haven't seen a copy thereof, but as far as we understand it, does not relate to any conduct of Ms. Jiba or Mr. Mrwebi. I have received, it seemed, there were earlier indications by Ms. Bauer that she seemed to want to make a contribution to these submissions.
Ms. Patlenda?
Thank you, Chair. Chair, from the evidence leader's perspective, we would agree that Mr. Hofmeyer is not, his conduct is not at issue before this inquiry. It is correct that the terms of reference refer to the Zuma case. That is correct, as one of the cases that this inquiry must consider. But I think that it would be pushing the intention behind the terms of reference to ask this inquiry to consider Mr. Hofmeyer's conduct in that case as part of what they are faced with. That's not, and I've never understood that to be the intention of including the Zuma case. What is before this commission is the conduct of advocates Jiba and Mrwebi. And so, to that extent, the evidence leaders would agree that Advocate Hofmeyer should not be asked to justify his conduct as contained in that case, unless Mr. Arendse could show us how that specifically refers to the terms of reference. Then, secondly, we wanted to be clear that, of course, there's no compulsion on any witness to come and give evidence before this commission. And Mr. Hofmeyer has come of his own free will to come and give evidence and to assist this commission. He has also come on the request of the evidence leaders who asked him to come and give evidence. And then the third and final thing I wanted to raise was the Mosing document. Yesterday it was called a memorandum, and Chair, you'll recall that I had indicated that we didn't have a Mosing memorandum on the Dropbox. I wasn't clear what was being referred to. There is a Mosing affidavit on the Dropbox. That's from the 5th of May. And so I would just ask Mr. Arendse to please clarify which document he refers to so that we are clear about what we're talking about so we know its relevance. And then, sorry, finally, on the question of self-incrimination, our submission would be that Mr. Hofmeyr and any other witness would be entitled to refuse to answer any question to the extent that it would incriminate him in other proceedings. It would, of course, it would be unwieldy, yes, but he would be entitled to refuse to do so. Thank you.
And we do understand that it is not only that it is not, Mr. Hofmeyr's conduct is not an issue here. We also understand, as Ms. Moroka said, neither of the people, Mrwebi or Jiba, who are the subjects of this inquiry, are on trial. That also needs to be understood. But with regard to Mr. Hofmeyr, you do not say that he may not be subjected to cross-examination. What you are saying is he may choose not to respond to a question during cross-examination. Now, if Mr. Hofmeyr's conduct at some or other stage arises during cross-examination, you are not saying that he will not or should not be expected to answer a question. What you are saying is if it incriminates, if it might incriminate him, he will not answer it. So he will be subjected to cross-examination because he has come to give evidence, he has been led to give evidence. And if his conduct, questions about his conduct arise during cross-examination, depending on whether there is likelihood that he might be incriminated, if he responds to the question, he can choose not to respond. Is that what you're saying?
Chair, yes, I would agree subject to this, which is that I think that what is being called for by counsel for Mr. Hofmeyr is for some indication from the chair about the limits of cross-examination on this particular topic. But yes, any witness that comes to give evidence before us must be cross-examined. Yeah.
With no limits on his examination.
It is understood that if Mr. Hofmeyr is of the view that responding to a question might incriminate him, he may refuse to answer the particular question. You're not saying that he cannot be subjected to
No, absolutely not. He
cross-examination.
may certainly refuse to answer a question if he thinks it will incriminate him.
Thank you.
Madam Chair, sorry, if I may respond to that.
We don't know what the panelist wants to ask. You might have to respond
Sure.
to her. Thank you.
Would the circumstances, I didn't catch your name? Tia. Okay. Would the circumstances be different if the questions that are being raised are in cross-examination are just used for purposes of actually indicating maybe, let's say, in a situation where Mr. Hofmeyr may have made certain comments in respect of comments made in a judgment relating to a particular conduct. Would the circumstances be different if the cross-examination is used well, the cases in which Mr. Hofmeyer is being pointed to, the intention is to show, for example, the fact that there may be comments that are raised in a judgment that may not agree with a particular conduct. Would those circumstances be different if one is using the cases for that purpose, instead of necessarily meaning your client is being put in a form of an inquiry?
Madam,
Sorry.
And
I want to piggyback on that question, but I think we're jumping from one council to the other, because I was going to ask this of you because you are addressing us. You see, the difficulty that we have is once you've given evidence, that evidence must be tested without the assumption that you are being made party to that inquiry or commission. The difficulty is that you need, if somebody makes a particular submission and arising from what my learned panelist is saying, is that it's common cause, this is what the judges said. And you can't discount it because that is what the judges said. And if Mr. Arendse wants to put a question mark as to what it is that you have said in evidence in chief, and you are then saying we must limit it because he's not the subject of this inquiry, in a sense, you are then limiting the testing power that cross-examination comes with. Because I want to test the veracity of what you said, the veracity of your opinions, the veracity of your observations, and how am I to do that if I'm not able to refer to a higher court's view of how you conducted yourself to test who you are? Because it's a different thing from saying, point by point, I will not answer that question because I'm not obliged to answer that question. But we can't then say Mr. Arendse is not entitled to ask the question. I don't know whether you understand the distinction that I'm trying to make, that I'm entitled to ask the question. You are entitled to say I will not answer that question.
Chair, sorry.
Yeah, you may go.
Chair, I didn't mean to suggest that this inquiry should not consider the views of the judges in that judgment. Absolutely, that judgment is before you, and you should certainly consider it. In fact, you have to. What I was suggesting is that we need some boundaries as to what the intention of the cross-examination is here, and perhaps Mr. Arendse will indicate. But if it's a question of, yesterday in argument, Mr. Arendse said to Mr. Hofmeyer, he suggested that he was going to compare his conduct to that of Advocate Jiba's conduct. And it would seem to me that that may not be an appropriate thing within the terms of reference here. But certainly, if Mr. Arendse wanted to ask a question of Mr. Hofmeyer that related to what the judgment records as Mr. Hofmeyer's conduct, he would be entitled to do so. And if Mr. Hofmeyer were to refuse to answer that question, then this inquiry would have to determine what weight is to be given to the fact that he refused and what evidence sits before you. At the end of the day, this has to be a fair proceeding and one in which Advocate Jiba and Advocate Mrwebi are able to test the evidence that's placed against them. And that is why cross-examination is allowed in these proceedings. But there must also be a balance between the rights of the witnesses that come not to incriminate themselves. So it's that balance that would have to be drawn, and I would suggest that that's about the weight that you give to the evidence, ultimately, that's before you.
Madam Chair.
You want to respond to that before we ask Mr. Arendse to...
Thank you very much.
Submission.
I think it's important to point out that there was no evidence laid by Mr. Hofmeyer as it relates to any of that case law or to the memo concerned. We absolutely acknowledge the fact that Mr. Hofmeyer can be cross-examined on the evidence he provided in chief, but none of these matters were canvassed in evidence in chief. That's the first point. The second point, it's not about generally Mr. Hofmeyer being incriminating himself. It is about the fact that the conduct that is discussed in those cases and in the memo concerned do not form part of the conduct that's under investigation in this inquiry or within the terms of reference in this inquiry. And for that reason, Mr. Hofmeyer will not answer questions based on that case law or on the memo concerned.
Thank you. Mr. Arendse, do you want to respond?
Thank you, Madam Chair.
Mr. Arendse, can I just, before you answer, you may want to respond to this. It's just occurred to me based on what Ms. Tjaart said, that there are, in addition to what evidence was led, there are also other affidavits in our Dropbox that Mr. Hofmeyer has made that he can be cross-examined on. That is evidence, and it would be open to you to do so. So I just throw that into consideration. It's not just the direct evidence that he led that you're entitled to cross-examine on.
That's the whole point. That's why I'm just marking the affidavit. The affidavit in this case is on the spy tapes case.
Can you read the affidavit in what?
But maybe if I can develop my own thoughts, ma'am. We are not surprised at all. We expected this in view of what the judgment says. And I hope that everybody, especially the media, reads the judgment. We are surprised, though, at the attitude of the evidence leaders. Their function, their main and their overriding responsibility is to place the facts, the objective facts, before the panel and not take sides in this matter. It's become increasingly clear to us as this hearing has developed, and that, hence the resultant delays, that holes have been plugged and more witnesses are being called or their affidavits are being solicited to shore up what seems to be a case against Ms. Jiba. But I would have expected the evidence leaders to abide the decision of the panel and not make any contribution towards the debate given their primary function. In fact, yesterday, Ms. Raja Badlinde had the opportunity, and Ms. Bauer on Skype had an opportunity to either at an early stage interrupt, intercept, or interpose and raise concerns in advance. They didn't do so. They now wait for Mr. Hofmeyer, who clearly has consulted his lawyers overnight whilst under cross-examination. This is not the first time, of course. We had an interruption last week when also he was given time to read certain documents. Now, if Mr. Hofmeyer refuses or fails to answer questions in relation to the Zuma matter, which is within the terms of reference of this Commission of Inquiry, the spy tapes matter, then the answer is quite simple. His evidence must be ignored, disregarded from the record. Now, Ms. Badlinde talks about the limits. I must indicate the limits of my cross-examination. And she also says that
I thought you said the panel must indicate the limits of cross-examination.
Well, I heard refer to I need to do so.
No, I don't think that's what she said.
Chair, to clarify, I didn't suggest that you had to indicate the limits of your cross-examination. That wouldn't make sense. It's for the panel to indicate the limits of the cross-examination. That was what was being asked for, as I understood it, from Mr. Hofmeyer's counsel.
Well, I that's what I heard. Now, Mr. Hofmeyer has no limits in chief in terms of his attack on the character of Ms. Jiba. He says in his written affidavit, he's also here to assist and he's also not taking sides. He said that in his affidavit here. He said that in his affidavit, which I'm also going to deal with, which was before Judge Delamo in the Western Cape High Court. he has, regardless of that, seen not to simply convey his knowledge of the facts. I may have differed with him about whether it was direct, indirect, and where he gained that knowledge from. He hasn't limited himself to that. He has sought to make a comment on everything that I've put to him. When I questioned, for example, the experience or lack thereof of Ms. Jiba's predecessors, all males, he would nevertheless make some sort of a comment as to why they were appointed. Now, the main function of this panel, Madam Chair, is to determine whether Ms. Jiba is a fit and proper person to serve in that high capacity. It is entirely relevant that the conduct of previous NDPPs, their experience in that position, must be evaluated. That is fundamental to your role of in playing and in being fair to her. Now, Mr. Hofmeyer, and he's criticized in the judgment, and it's critically important to get to that part of the judgment. He criticizes Mr. Nuka and Mr. McCarthy. They played fast and loose with the rules of the NPA. Ms. Jiba is accused by Mr. Hofmeyer of ignoring the rules of the NPA. Even though I say to him, well, but the case law says this is all that's required for the NDPP to make a racketeering decision. He said no, he disagrees. He says there are other rules within the NPA that were ignored. The judgment in the Zuma spy tapes case that's written by Mr. Justice Nafsa deals with that issue. It deals with that issue, and it demonstrates that Mr. Hofmeyer himself played fast and loose with those rules. In his affidavit, which is before you, the affidavit is the one that is at page 91 to 241. It's a massive affidavit. That affidavit deals with what the panel must deal with in its report to the President. I don't know if the affidavit can come up on the screen or whether you have a copy of the affidavit. This is the affidavit which was deposed to by Mr. Hofmeyer, notwithstanding the fact that he was not the decision maker in the Zuma spy tapes matter. Mr. Mshe was the decision maker. And the judgment criticizes him for doing so, and it's relevant to this inquiry. In his affidavit...
Why is it relevant?
It's relevant because he was not the decision maker. There are aspects of Mr. Hofmeyer's evidence where the converse is the case. Even though Ms. Jiba, it is common cause, was the decision maker in the decision to prosecute Mr. Boyson, the decision to withdraw the prosecution initially of Mr. Ndluti, he says no. Through a corruption of processes within the NPA, that led to the wrong decision that was made ultimately by Ms. Jiba. And then he criticizes very vociferously yesterday. He says, when I say to him, well, there we are, there's Advocate Mosim's memorandum, affidavit, the prosecuting team, they placed it before Ms. Jiba. The two cases that we referred to, including the Govan judgment, Chow, the Vries, and the Govan judgment, says all that the NDPP is required to have before him or her is a memorandum to set out more or less what the nature of the charges. That's enough. He said, no, that's not enough. He says that the difference between what he did and what Ms. Jiba did is that the courts have been scathing of her conduct. What does that do? Mr. Hofmeyr has placed his own credibility on the line. It is so fundamental to the rules of fairness in a trial, is that a witness who himself or herself has got no credibility, that witness opens himself or herself up to cross-examination in relation to that witness's character and conduct. It can't be that Mr. Hofmeyr is allowed to badmouth Ms. Jiba, whose job is literally on the line, because increasingly it's turning into a disciplinary inquiry of her conduct. And his own conduct can't be tested. Because if this panel finds that it's a case of, maybe it's not such a good epithet, but I'll use it anyway. If I'm wrong, just slap me. If it's a case of the pot calling the kettle black, then clearly
I was just about to say, I hope you're not taking that line in your cross-examination because you want to show Mr. Hofmeyr, or you want to show this panel that Mr. Hofmeyr is calling Ms. Jiba a black pot, and he is probably even blacker.
No, that not.
I hope, you make it sound like that.
The reference is not to it. It's a reference to what it actually means, is that someone who himself or herself is not so good or bad can't call another person good or bad. That is the only reference to it, and I make it in that context. Now, in this matter, or arising from this matter, this panel, or certainly we will argue this panel will be required to evaluate the evidence in the light also of previous NDPPs, their terms of appointment, their levels of experience, and the panel has got to be fair to Ms. Jiba. The panel will also do it with reference to the conduct of previous NDPPs. That is being fair to Ms. Jiba. Now, the conduct of which Mr. Hofmeyr...
Can I say just for a minute there, Mr. Arendse? You're probably, because I don't want us to cloud what you're trying to say, because I understand what you're saying. But this proposition about other NDPPs, shall we just slice it out of this argument, because I would want us to engage on that one. Whether we're obliged to take conduct of other NDPPs who are not before us, who are not able to answer questions before us, and take their conduct into account. It's something different to say their expertise into account, but if you want us to take their conduct into account, but they're not here before us, and they're not here to answer about their own conduct, then the issues of fairness must arise. But I don't want us to deal with that now, because you want to deal with Mr. Hofmeyr, and I'd rather you went there.
Thank you, Advocate Moroka. It relates to the issue of proportionality. Sometimes we do wrong, but other people in the same position or a similar position also do wrong, and it's worse than what you did. And when you have an inquiry that's rooted in fairness, you look at that, because it relates to the principle of proportionality. Now, in Mr. Hofmeyr's case, he accuses Mr. Ngcuka and Mr. McCarthy of subverting the processes of the NPA. He accuses them of colluding with former President Mbeki in deciding not to prosecute Mr. Zuma at the time. Those allegations are serious and are addressed by Mr. Justice Nafsa in his judgment. Now, if that's the case, then frankly, and so we'll submit at the conclusion of this hearing, it makes what Ms. Jiba did, even if it is proved in inverted commas, look like child's play. Now, the integrity of the institution was undermined and compromised in the decision by Mr. Hofmeyer or by Mr. Mshe, because notionally or nominally Mr. Mshe took the decision, but the judgment demonstrates that Mr. Hofmeyer was the key person behind that decision. Now, if in that event, the court also makes a finding that far from wanting to protect and promote the integrity and the independence of the NPA, Mr. Hofmeyer, so the judgment says, not me, Mr. Hofmeyer does exactly the opposite. Sorry, I've got my...
Yeah, can I take the opportunity while you...
My wife are also on my phone. Sorry, I'll...
Your phone, and hopefully everybody else also ensure that your phones are off. While you're doing that, is the conduct of anybody other than Ms. Jiba in this case really so relevant, even in questions of proportionality, when the single most, or perhaps the only issue before us is whether Ms. Jiba, and of course Mrwebi, but Jiba in this case, is fit to hold the positions? That's the question we should answer.
That is the question.
How her conduct compares with anybody's, including Mr. Hofmeyer. Is it really that relevant?
It is so absolutely relevant. And this panel, this honorable panel, with respect, if it simply adopts that approach by only looking at Ms. Jiba, then that approach will not only be far too narrow, but will also be grossly unfair. And the reason is that Mr. Hofmeyer has come here and tendered evidence on the workings of the NPA, the inner workings of the NPA. And within that context, he has said that Ms. Jiba was party to subverting and corrupting the inner workings of the NPA, and together with others that he mentions. Now, if you yourself, because we mustn't forget, and this is what, with respect, the evidence leaders should perhaps refocus their mind on. This inquiry essentially relates to judicial criticisms of Ms. Jiba in 4 cases. Now, how can it not be relevant that in one of those cases, the spy tapes case, in one of those cases in which Mr. Hofmeyer was intimately involved, how can that not be relevant to this inquiry? His conduct in that case. And
even where those criticisms were leveled against Ms. Jiba for different purposes, even in that case.
Madam Chair, it is not for different purposes or different reasons. In the case of Boysen, in fact, I try to be fair to Mr. Hofmeyer. I said to him, can we, and it's on the transcript, can we restrict your cross-examination to matters that only fall within your personal knowledge? And he elected not to do so. He said, no, I know everything about the Boysen case. I know everything about the Mrwebi case. And of course, he knows everything about the spy tapes case. He cannot now run away from what he did in the spy tapes case. He must answer to them. If he doesn't answer, it is grossly unfair to Ms. Jiba that he is not required to do so. Of course, his own conduct is not at stake. In fact, I am not accusing him of anything. I'm going to read back to him what the Supreme Court of Appeal has said. And of course, the judgment didn't go beyond that, which is not surprising. I'm reading to him back, and I'm in the context of what the court has said. I want him to answer about criticisms that he made against Ms. Jiba. In that context, I want to cross-examine him. For example,
Find out before you go there. Because if you make an example, there must be a response to that example. And I accept that you're entitled to do it. And therein my difficulty with asking counsel about your rights to cross-examine. The difficulty that I have is there's a fundamental protection enshrined in the Constitution about self-incrimination. And I'm saying to you, what of that right, of anybody?
Advocate Moroka, two things. How can there be any incrimination or self-incrimination when Mr. Hofmeyer has not been charged, has not been accused of anything? This is a judgment.
Mr. Arendse, he hasn't been accused of anything. But once you ask him a question that will tend to incriminate him, he's entitled not to answer that question. That's the law.
I'm trying to respond to you, Advocate Moroka.
You're trying to respond to me with reference to what was said about him, not what he said. Because if he says it and incriminates himself, we can't force him to do it.
I answer in the following way. This is a judgment delivered on the 13th of October 2017. It's more than a year that this judgment, and of course this is a public document, these allegations are contained in this judgment. What I'm going to do is to go through what is said in this judgment. Now, how can that possibly incriminate him? Why didn't he do something about the judgment?
Doesn't it depend what you are going to ask him? We're talking about questions that you will pose, which, if in his view, they expose him to self-incrimination, or if they in fact expose him to self-incrimination, surely he has a right not to respond, even if it is information which is out there in the public domain.
It would be absolutely extraordinary that a judgment that has been available and that he knows about and that he read again last night and sought counsel in relation to, and now he is refusing to answer questions on that judgment. I am not going to suck anything out of my two thumbs. I am going to put to him what is in this judgment, and I'm going to ask him a question arising out of the findings of the court. And as my colleagues already alluded to, and I think his own lawyer has indicated, let's do it on a question-by-question basis. If he refuses to answer, then we will argue at the end either that all of his evidence should be ignored or some of his evidence should be ignored.
Chair.
Madam Chair, I'm not done. As I said, we're not surprised by this. We're actually pleasantly surprised that he's here today. But what obviously I also need to confer with my team about, because we clearly heard the basis of the submission for the first time. Can we have 5 or 10 minutes to confer? I want to take, maybe there's something I said that I shouldn't have, or maybe there's things I should say that I haven't thus far said to the panel or made submissions to the panel.
Can we just hear what
Yes.
Ms. Butlander
Chair,
needed to
Chair.
say?
Before we do that, I do, and I did it with everybody else, Mr. Arendse, and the judge has spoken to all of us. We must be very careful how we address each other. There must be respect. There must be an understanding that this is not a trial. This is, and so when you talk about your colleagues, please do it with the collegiality that is called for.
I think I have done so, Advocate Moroka.
Not Mr.
No,
Arendse.
let's give Ms. Butlander an opportunity to say what she needed
Chair.
to say before we...
In light of the quite serious things that were said this morning, Advocate Bauer would like to respond. If you just give her a minute to respond on the Skype, please.
Thank you.
But Madam Chair, I have not completed my submission.
You had asked for an opportunity to confer with your colleagues, isn't it?
So
Yeah.
that if I'm done, I will indicate to you that I've made my submissions, and perhaps Ms. Bauer should hear the remainder, if any, of my submissions.
Okay. I thought you wanted to go now. You wanted an opportunity now to confer with your colleagues. Okay.
Yes, Madam Chair, that's
Yeah.
exactly what I'm asking for.
Yeah.
I can't sit here with 2 or 3 notes in front of me with different
Yes.
handwritings
Yes.
and make out what
I
they're trying to say.
I understand. I thought you had completed your request, but you may proceed if there was something you wanted to say in addition.
Madam Chair, I've asked for time out to confer with my colleagues,
Yes.
5 to
Yeah.
10 minutes, and then come back to complete my
Yes.
submission.
But we don't know what Ms. Bauer needed to say. It might be something that you would want to consider when you confer with your colleagues. Is there anything that you would say that Mr. Arunse would want to take into account when he confers?
Well, I do, Madam Chair. At the start of his submissions, he made the allegations that the evidence leaders have now sought to solicit affidavits to shore up case. And
Okay.
we consider that to be a veiled allegation of some sort
right.
of bias that's been demonstrated.
Okay, then I think you can make your submissions after he has made his, okay?
I'll do
It is
so.
not something that he might want to take into account when he confers with his colleagues. We will give Mr. Arons an opportunity to confer. How long do you think you will need?
I think 10 minutes for the outer limit.
10 minutes.
Try and be back sooner.
Okay, thank you. We will adjourn for 10 minutes for those purposes. Thank you. Thank you, everybody. Why would they empty so?
Are you interested?
You want to be part of this fight. Thank you, Mr. Arendse.
Thank you, Madam Chair and honorable members of the panel. And thank you for allowing us some time out to deliberate with our client. I don't have to tell you how important this matter is for her. May I
It's important for all of us.
Yeah, thank you. May I just remind ourselves of what the judicial criticisms say about Ms. Jiba. The first one is the poison matter, where she was described as mendacious, in other words, that she lied under oath. That finding was not shared, lest I be accused of using some other stronger word, was not shared by Judges Lagodi and Hughes, because there was now an explanation of how the whole issue of the Denica's sworn statement, how that came about. The other judgment is the matter that Mr. Hofmeyer became heavily involved in, and that is the spy tapes matter. And in one of the preliminary matters, there was a criticism from two judges, Justice Murphy and a judge, the appeal court Judge Brandt. So those, and in the case of Mdluli, two judges, Justices Lagodi and Hughes, said that, criticizing heavily Ms. Jiba, that she did everything in her power to protect Richard Mdluli. Now, those, I think, I fairly, in very short summary, describe the criticisms of Ms. Jiba. Now, in none of those judgments do they say that Ms. Jiba used the NPA for political gain or to support some factional political interest. But Mr. Hofmeyer says so, and I'm going to take you to his affidavit, which is before you. None of the judgments say that Ms. Jiba used the National Prosecuting Authority to prosecute people who fight corruption. He mentions names. Mr. Hofmeyer says so. All the good guys, Breitenbach, Godan, McBride, and a few other people. None of the judgments say that the conduct of Ms. Jiba corrupted or compromised the integrity and independence of the NPA. Mr. Hofmeyer says so. Now, the honorable members of the panel, in evaluating whether Ms. Jiba is a fit and proper person, is required or would be asked, I would expect, by the evidence leaders to accept, amongst others, Mr. Hofmeyer's evidence in this regard. Because, frankly, I can't disagree that they're important considerations. Very important. Mr. Hofmeyer says the NPA has been dysfunctional. He says there was only one period of stability, and that was really during the period of UNUCA. And of course, that's at the inception of the establishment of the NPA. Isn't it important to look at what he now says about Nuka in the spy tapes case? So, the thrust of the judgment is that Mr. Hofmeyer's own credibility, to put it mildly, is suspect, and that he cannot be trusted. Now, let's go to what he says and having said that, notwithstanding the very clear terms of reference of this commission of inquiry, the evidence leaders have had these affidavits. They never said to Mr. Hofmeyer, please, we haven't asked you to speak about this, that, or the other. Please be clear that this is what the inquiry is about. When Mr. Hofmeyer gave his evidence in chief, it was widely reported in the newspapers what he said. And the narrative is always the same. The name dropping is the same. It's Ndludli, it's Jiba, it's Edward Zuma, it's the president. All these people, it's Pende that now put, what's it, 2 million rand in Boyson's boot. Now what has that got to do with Zuma? No one stopped him from mentioning that evidence.
But then again, what does what the media says have to do with the evidence before us? We must look at the evidence that is before us. That is important.
I'm very happy to hear that, Madam Chair. I'm referring to what he said in this room.
Let's confine ourselves to what he said in this room and not about what he said in the media.
Madam Chair, with respect, in this room, the evidence from Boyson was that this money was put.
Yes.
There was some...
can you kindly confine yourself to what is said in this room and the evidence that is before this?
Yeah.
Can I say this, Mr. Arendse? I see you want to go back to what he has said. Can we accept that Mr. Hofmeyer has led evidence in the manner that he led it and said the things that he has said, and we accept it? Can we accept that you are entitled, I'm told I'm not speaking loud enough, can we accept that you are entitled to cross-examine? And I'm saying this really to help the chair so that we can curtail the proceedings. I accept that you are entitled to cross-examine Mr. Hofmeyer on what he has said. Can we confine ourselves to the issue of whether you are entitled to raise the issues raised in the judgment? Don't take us back to what he has said, because we accept that you're entitled to cross-examine on that. But there is an issue about whether you can put to him what was said in the judgment. Shall we confine ourselves to that, and then we then can take a decision on it? Because I can see you want to go back to what Mr. Hofmeyer has said. We accept that you're entitled to cross-examine him on that. But shall we confine ourselves to whether you are entitled to cross-examine and put to him the comments of the judges in respect of Mr. Hofmeyer? Then we can move. But going back to what he said on the previous occasion, we'll just delay the proceedings, because we accept you're entitled to cross-examine on that.
Thank you. The one thing that I do agree with Mr. Hofmeyer, there's not much else, is context is important. Now, before I can go to the judgment, it is important, and this is a public hearing. The media side, the public, because there's other people, because of public interest. They all claim that this institution called the NPA is falling apart. And thank goodness for the new appointee, because, otherwise, and we are all agreed, it is such an important institution. And Mr. Hofmeyer in his affidavit has expressed strong views. Now, it's important to get those strong views. He is given them, and in the context of discussing whether or not only that I should I know with respect that I'm entitled to cross-examine. The issue is about whether what is said in this judgment should be put to Mr. Hofmeyer, and whatever it says, whether he is required to answer to them in the context of what he said. And that is, I want to take you to what is already before this commission. And the important affidavit is the one that he made, which is the one on the 24th of January 2019, which is at pages 449 and 468. And to underscore, I've already referred you to the other affidavit which he made in 2015, 31 March 2015. And there's the one that I'm going to refer to now is the 24th of January 2019 at pages 449 to 468 of this bundle. The other affidavit which Mr. Hofmeyer made on the 31st of March, that inter alia refers directly, and I'm not going to take it further than that, the involvement of NPA officials in Nell's arrest. That's at page 211. That affidavit is the one dated 31 March 2015, and that's at paragraphs 211 of this paginated bundle that I have, at paragraphs 458 through to 214, and of course he also gave testimony on that issue. Now this latest one, Mr. Hofmeyer deposed to on the 24th of January, (2019), where, and it's at page 449. And what he says here, it's what's caused public outrage. I'm one of them. Public outrage because of this absolutely critical institution in its fight against crime and corruption. And this is what he says at page 453 at paragraphs 33 to 50. He says, it was the clear intention of Parliament in both the Constitution and the NPA Act that the NPA, the NDPP and DPPs and prosecutors must perform their duties independently without fear, favor or prejudice. NPA and the prosecutors must be seen to be independent. For the prosecuting authority to be successful, it has to be credible and trusted by the public. Trust and credibility is especially important in relation to difficult decisions where there is considerable evidence, but the evidence is not sufficient to satisfy the legal requirements to institute a prosecution. This judgment discusses the role of prosecutors in that process, and in particular, Mr. Hofmeyer. Thus, he says, it is vital that the NPA must be free from interference and political considerations. The judgment deals with that. He says, it is imperative that these factors must play no role when taking decisions whether or not to prosecute. The abuse of prosecutorial powers to advance political agendas has been one of the issues that has impacted most severely on the perceptions of and the public confidence in the NPA. This judgment speaks to that. And I would submit it is a critically important factor when this panel weighs up and evaluates the conduct of Ms. Jiba and whether she's a fit and proper person. Then he says, the fact that the NDPPs and the DNPPs have on a regular basis formed the object of negative media reporting has severely impacted on public perceptions and confidence. And what does he do? Before he says this, he says, this institution has been embroiled in high-profile cases which has eroded the public confidence. This judgment is not mentioned. Then he says the NPA. This is all from, I'm reading from paragraphs 33 through to it's 33 to 50 pages 453 and 454. He says the NPA should never be seen as an extension of any political party or to give effect to its agenda. Now why would he offer to say this in his affidavit to this panel if it's not relevant to the debate? The evidence leaders never stopped him and said, no, Mr. Hofmeyer, please, we are just confined to what actually happened in these 3 or 4 cases. Then he says, even more dangerously, in a number of prosecutions, the NPA has essentially been perceived to be acting on behalf of a faction of the ruling party, such as the prosecutions of those who were opposed to the majority grouping in the ruling party at the time. An example is the prosecution of Bodan. The NPA has also played a leading role in getting rid of those in law enforcement who were prepared to do their job properly. Examples are the prosecutions of McBride, Dramat, Boysen, Sabia, Breitenbach, Pillay, and Van Locherenberg. Then he talks about Boysen, and then at paragraph 49 he says, it is a demonstration of how normal NPA processes were abused in this matter to charge Boysen where there were no substantial evidence linking him to any crime. Now, this affidavit is made at page 441. The heading of this affidavit is this inquiry, not some other proceeding. Then at he refers directly to his affidavit in the Zuma matter at page 461, paragraph 108. He says, in my affidavit in the Zuma matter, which I am informed is already with the Commission, I deal extensively with the role of Jiba and Mrwebi and others in protecting Celebi. At the time, the investigation was under huge pressure from the rest of law enforcement, as well as from the President himself. At paragraph 121 on page 462, he again refers the inquiry to his affidavit filed in the Zuma matter, which I'm informed is in its possession. And this is where it becomes critically important, because now this is the link for Mr. Hofmeyer. At page 463, paragraph 122, a very concerning development trend that emerged under Jiba was almost institutionalized by Abrams, was to prosecute those who were perceived as obstacles to corruption and the capture of the state. This included particularly persons in law enforcement, later such as Breitenbach, Dramat, Sabia, and McBride. Now, we submit, my lady and honorable members of the panel, that these are matters squarely placed in issue by Mr. Hofmeyer. And he's got to answer them. The questions, and already, well, okay. The questions I'm going to put to him that arises from the judgment is in relation to these submissions that he has made. It won't be extraneous, it won't be irrelevant, and if they are, then I would expect there to be an objection from my colleagues, or the panel will, I've just read it now. Yeah. Then the panel will intervene. So we submit, honourable members of the panel, that we should be allowed to proceed with the cross-examination of Mr. Hofmeyer in relation to this judgment. Thank you, ma'am.
Ms. Power, do you want
Thank you,
to...
Madam Chair. It seems there's a couple of things I need to deal with, but at the inception of what Mr. Arendse had put to the inquiry, he made the allegations, quote unquote, that the evidence leaders were soliciting affidavits to show up a case. And I must place on the record, there is also an accusation of us being biased. And I must place on the record, we have as to the difficulties in obtaining affidavits, the time constraints we have faced, and the scheduling of witnesses. And I find that this is a public inquiry, and those allegations of bias are completely uncalled for in the context of this inquiry. May I also place on the record, and maybe this is entirely germane if we go into the Zuma case, one of the last statements that has been put onto the Dropbox is that of the counsel who had been involved in the Zuma matter on behalf of the NPA. And you see that at folder M number 23, it was added to the Dropbox on Monday. It was foreshadowed by me informing Mr. Arendse at the time I consulted with Advocate Kennedy, that Advocate Kennedy had expressed a view to us that as far as he was concerned, the approach that had been adopted by the NPA was in line with the advice that he had rendered at the time. And if I take you to what Advocate Kennedy had to say in that matter, I'm going to take you to two paragraphs, which is paragraph 47, where he says, what does appear relevant for present purposes is that the allegations against Advocate Jiba in this inquiry is to make it clear that the stance of neutrality was not a frolic of her own. It was a position adopted by her as client and us as a team collectively. We furnished our legal advice to her and her colleagues for the reasons already summarized. She was in any event, as I recall, not keen to adopt any definite stance on the issue of production of the disputed materials. But when that approach was suggested to her by us as counsel as being prudent, cautious and sustainable, she accepted the advice and gave us instructions to act accordingly. We proceeded to act in accordance with that position. And I take you to one further paragraph. He then quotes the paragraph in which Judge Nafsat, paragraph 41, criticizes, I think the word used was supine, and he says in 51, these criticisms by the SCA of Advocate Jiba overlap with those of Matopijay, which I have addressed above. Again, it is to be stressed that what was done in relation to the conduct of the matter and in the preparation of Advocate Jiba's affidavit was done on the basis of careful discussion and professional legal advice which we furnished to her. She gave us instructions which accorded with that advice. Now, not only did I inform Advocate Arendse when I knew what Advocate Kennedy was going to say, I also, in consultations with Advocate Hofmeyer, relayed to him that we had been told this by Advocate Kennedy, and he had agreed with me that I had acted on legal advice of Advocate Kennedy in relation to that issue. So I am very taken aback with the accusations of bias on the part of evidence leaders that has now been leveled. But let me also say, we're also being accused because we didn't deliberately interfere yesterday when Advocate Arendse read copious paragraphs of a judgment to the proceedings and left Mr. Hofmeyer to answer in that. I've been chastised by the inquiry for not interfering and been told to deal with things in reply. Now we're being told we should have interfered. It's either one or the other. We must either allow them the opportunity to do so or not. And thirdly, it's not the evidence leader's position that Mr. Hofmeyer can't be cross-examined or that he can't be cross-examined on the judgment. The point was simply made, as Advocate Budlander had indicated earlier, what the parameters of the terms of reference are that we as evidence leaders had investigated. And finally, I must point out that it is also not correct to suddenly change a Mozzing memorandum to a Mozzing affidavit. The witness is perfectly entitled to ask what is he being questioned about. We have no knowledge of a Mozzing memorandum, firstly, and secondly, the Mozzing affidavit to which reference is being made was deposed on 5/8/2015.
It's Mosing, isn't it? We have tried to make sure that people's names are pronounced properly. I'm so sorry for interrupting.
My apologies, Advocate Baroko. The Mosing affidavit was deposed on 5/8/2015. It was long after Advocate Jiba had taken a decision in 2012. Yet the proposition that was put to the witness was that the Mosing now /affidavit/memorandum was before Advocate Jiba in 2012. It's not fair to a witness for submissions to be put that is not accurately put to him and he's expected to answer. And that's not correct. Finally, the terms of reference of the inquiry must also be properly represented. While it relates directly or indirectly to the conduct of Advocate Jiba, there are a number of cases to which we are referred, but the inquiry is told you're relating to a fitness and propriety to hold office, and with due regard to all relevant information. You are certainly not restricted to these 4 cases. Those are our responses. Thank you.
Thank you. Thank you, Ms. Bauer.
Madam Chair, may I respond to some of those?
Yeah, she must. Yeah. Mr. Arunsa, you wanted to raise something?
I just wanted to respond to some of the comments made by Ms. Bauer.
Before we give you, ma'am, an opportunity to respond, okay? Just bear with us. Thank you.
The bias that I alleged was in relation to the evidence of Mr. Hofmeyer and the ambit of his evidence in chief. And perhaps, I suppose it's because Mr. Hofmeyer is legally represented, but then again, I wouldn't expect his own legal representative to curtail or to stop him and to tell him, sorry, you're venturing outside the terms of reference of this inquiry. And it's that bias that I was referring to. To the credit of the evidence leaders, some 2 weeks ago or so, Ms. Bauer called us about the memorandum that they solicited from Advocates Kennedy and Algerein, both senior counsels. And that is before the panel. And that panel, that memorandum from Advocate Kennedy is critically important to the inquiry in relation to Ms. Jiba's conduct in the spy tapes matter. But that is in one of the preliminary skirmishes. The Zuma tapes saga, as Mr. Hofmeyer I think well knows, has many stages, and one of this was concerning the discovery of the spy tapes, and it's that criticism of Ms. Jiba in one of those matters. It doesn't concern this Zuma case that is now being debated. The paragraphs that I read in Boyson, the panel will recall that I had offered to Mr. Hofmeyer that we can call it quits and not go there. I, in our defense, was compelled to read back to him what the judge said, because when he, in his evidence, said what the judgment was saying, it didn't accord with what I read back to him. The Mosing affidavit memo, I'm going to deal with still in cross-examination with Mr. Hofmeyer, and is not part of the current debate that we're having, whether or not we should be permitted to cross-examine Mr. Hofmeyer on the Zuma judgment. The terms of reference, I agree with Ms. Bauer. It's not only confined to the judicial criticism, but is a broader inquiry about whether she's fit and proper. And it's for exactly that reason that what Mr. Hofmeyer says about her and says about the NPA, it's for exactly that reason that this judgment is critically important to be taken into account by the panel. Thank you, ma'am.
Thank you, Mr. Arendse. Can we get a response from the legal assistant?
Madam Chair, thank you very much. May I request just a short break to just confer with Mr. Hofmeyer about the things that's just been said. I just want to make sure that I present his views accurately.
It is already 1 o'clock and it's already lunchtime. But I don't think we can take a break. Can you do it within 2-3 minutes? Just sitting there.
Just a few minutes. We'll just step away because otherwise we have a problem with some of the mics. But we will step away, but we won't take very long.
Yes, because we want to take a break for lunch, so that Mr. Arendse can proceed with his cross-examination. So we don't want to take too long with the break that you need. So you may step away.
Thank you.
So that you come back and respond before we go break for lunch.
Thank you, Madam Chair.
Are you ready for us, ma'am?
We are indeed, Madam Chair. Thank you very, very much for the panel's patience. We really appreciate the opportunity. In response to what's been said previously, we would like to underline the following. A mention was earlier made, which we submit was very uncalled for, to being surprised that Mr. Hofmeyer arrived here today. We are not certain what was meant by that, but we can report that over the past 2 days, up until today, that we've had a significant interference in both our email accounts and also the email accounts of those who were assisting us in preparation. It sounded rather sinister. In addition to that, just to put it in perspective, that seriously impacted on our ability to prepare, but we've pushed through, we've arrived here regardless. There is absolutely no indication at all by Mr. Hofmeyer that he wasn't prepared to give evidence. He is absolutely prepared to give evidence. He's never had any problem being cross-examined either. What the problem was the extent to which he would be cross-examined, and in particular the cases that we've referred to previously. The reason for the concern was that the opportunity of cross-examination may be abused and that Mr. Hofmeyer would become the subject of the inquiry in the process, while such an inquiry hasn't been constituted properly. The inquiry is not about Mr. Hofmeyer, and the inquiry is about Ms. Jiba and Mr. Mrwebi. In addition thereto, what we would like to the panel to consider is Mr. Hofmeyer will be required, or it apparently will be required, to respond to certain remarks made by a judiciary in the case law previously mentioned. In addition to respond properly to whatever statements have been made by the judiciary, Mr. Hofmeyer would like an opportunity to consider all the evidence or affidavits at least that were before the court in arriving at those conclusions in order to determine whether Mr. Hofmeyer is at risk of implicating himself in something that might become the subject of an inquiry or other proceedings. In addition thereto, we would like the panel to consider that Mr. Hofmeyer has deposed to that affidavit in 2015, which is 4 years ago. At the time, it was done in consultation with counsel as well. Mr. Hofmeyer would like it put on a record that his conduct is not on trial, but he is concerned that by allowing that cross-examination, that he will in fact be on trial by commission. The fact that that cross-examination may continue would also impact on his rights. Mr. Hofmeyer is not in a position to call witnesses or to place or offer other evidence before this commission when he is being implicated or when it concerns him. He does have a right against self-incrimination, which he will choose or elect to exercise. The terms of reference does not include Mr. Hofmeyer's conduct. He also does not have the right to cross-examine other witnesses when it relates to his conduct, which may surface in such a cross-examination. And Mr. Arendse was very clear that he wants to raise the case law with the purpose of referencing Mr. Hofmeyer's conduct to that of Ms. Jiba for comparative purposes. So it is clear that there is indeed going to be made mention of Mr. Hofmeyer's conduct and that it will be under scrutiny before the panel. And for those reasons, Mr. Hofmeyer is of the opinion that his rights will be infringed upon. In summary, Mr. Hofmeyer says that he would want to refrain from commenting on issues that might implicate him, and he would like to make a considered decision about whether it might possibly implicate him or not, which he hasn't had an opportunity to do at this point, because he doesn't know which questions are going to be asked or where the references will be made thereto. In addition thereto, his conduct is not the subject of this inquiry.
Please don't repeat that. I think you've said that like 4 times.
I counted 10.
Well, then I consider the point made, Madam Chair. Those are our submissions.
Okay, thank you.
Sorry, Madam Chair, I have just been informed by Mr. Hofmeyer. I did leave something out. Mr. Hofmeyer has indicated that to the extent that these may implicate him, he would like an opportunity to consult with senior counsel as well.
Thank you, ma'am.
Thank you, Madam.
Madam Chair, may I just...
Just wait a minute, Mr. Just wait. Ne? Can we break for lunch and adjourn until lunchtime, and then we will come back and proceed with our consideration of the issues and determine if we will proceed with cross-examination, okay? Subject to our discussions earlier and subject to all of these submissions, okay? We'll come back. Okay. After lunch, we're going to have a shorter lunch, ne? Yeah. We come back at 2 o'clock. It's fair enough, I think.